Hello students, welcome to yet another interesting episode of Recitals in-Depth, where we are going to cover the topics which have featured in the month of July 2024 for the subject of polity and governance. The topics are broadly falling under the themes of Parliament and its key legislations, Judiciary and important judgments, fundamental rights, and finally, governmental schemes and policies. So the next topic for our discussion is the Delhi Urban Land and Immovable Property Records Bill of 2024. This bill is a very key legislative tool which has been put forward by Ministry of Housing and Urban Affairs of the Government of India with respect to the sustainable planning and urban management of Delhi. So now let us try to understand what does this key legislation holds. So again, the structure of this discussion will be same, like we will try to understand the context. Secondly, we will try to understand what are the problems which are persisting with the management of urban land records. Then we will try to apply this understanding of the problems of urban land records to the present scenario which is occurring in the state of Delhi. Since this particular bill aspires to provide a recording system of the urban land for the state of Delhi. And then we will try to understand the objectives or the various provisions of the bill and what are the intended benefits that we can actually accrue from it. So, starting from the first point, which is what is the objective and the context behind this particular bill. So, MOHUA, which is in short for Ministry of Housing and Urban Affairs, they have started deliberating to come out with a bill by the name of the same topic that we had started learning, to do two important objectives, which is to go for the digitalization of the land records, which is the urban land records, and also the records with respect to the immovable properties. What are these immovable properties? Immovable properties, as the name suggests, it means that those properties which have got direct correlationship with the land. That is, immovable properties can be the flats, apartments, shops, any kind of real estate properties which any individual has been owning. And the second important aspect of the object which this particular bill aims to achieve is that there has to be enough transparency and accessibility with respect to the common persons, so that they should be able to access whatever data with respect to the land. They should be able to access it in a very accessible, affordable manner. That is the core context and the objectives of why MOHUA or the Ministry of Housing and Urban Affairs have introduced this bill at first place. But we need to ask further more important question, that what was the need in front of MOHUA to introduce this bill? And the core of this issue lies with respect to how the urban land records are managed, or the records with respect to the immovable properties are managed in the cities of our country and in Delhi in particular. So Delhi being the capital of our country, it does not mean that the system is way much better as compared to the other cities of our country. Of course, being a capital of our country, more resources are here, but still a lot of lacunas are there with respect to how the governmental agencies manage and maintain the land records and the immovable property records. And this is why the Ministry of Housing and Urban Affairs, they felt the need that ultimately they have to come with a new law so as to ruffle the rough edges which persistent in the management of the urban land records. So what are the major major problems associated with managing the urban land records? For that, we need to understand a concept of record of rights. That is the key concept which is associated over here. Record of rights. And what is this record of rights? It is nothing but a document which contains the details about the land or any immovable property, about its ownership rights, and thirdly, about what kind of property or land it is, whether it is an agricultural land or whether it is an residential land or whether it is an industrial land. And lastly, it comprises of information with related to, are there any mortgages associated with that particular land? So these are the major details which are actually held by the record of right. So to make you understand with the help of a diagram, let us go to the previous page, which is this. I am sure you are able to see this particular diagram, and in this diagram we are able to see that the entire city has been divided into smaller parcels of land, and this every parcel of land has their own record of rights, which contains the details about the land, that is the dimensions of the land, then the ownership, then the kind of the land, and ultimately are there any mortgages which are associated with the particular land. And ultimately, although it seems quite logical and intuitive that the governmental agencies should be having this segregated like mapping of all the lands which are available in the city, so that they can plan through which areas they have to create a road, through which areas they have to create a park, through which areas they have to create a drainage line. So ultimately, but that is not the reality of our Indian urban management systems. It is a very far reality that the governmental agencies have such kind of delineated urban land records with them, and that is the core agenda that the Ministry of Housing and Urban Affairs came up with this particular act. Now, to understand it even better, like what are the major problems which are associated with urban land management records, or with respect to the records associated with immovable properties. So, the majority of the problem which is associated with managing the land records, it is that ultimately there are no ROR present. So RORs are not present. ROR short for records of rights. And secondly, if they are present also, if in case they are present, it is not updated. The data contained in that ROR is wrong, and ultimately it is not being maintained in the desired format which has been prescribed by any further law, and ultimately there are multiplicity of laws which mandates the governmental agencies to actually record the data with respect to the urban lands or the immovable properties. And apart from the multiplicity of laws, there are multiplicity of institutions as well, which are capturing the data with respect to urban lands. And this creates an absolute cocktail with respect to the management or recording of the data with respect to the urban lands or the immovable properties. And it creates a lot of trouble for the policymakers, for the urban planners to actually design such kind of sustainable urban ecosystem or environment where people can actually live with a greater ease. And that is the core requirement with respect to why this bill was required. And to juxtapose these problems which we actually identified with respect to the storage of or the data with respect to the urban lands, if we'll try to apply it in Delhi, again it happens the same ways, that there are multiplicity of laws which governs the recording of data. That is, specifically in case of Delhi, there is a act called Delhi Land Reforms Act, and secondly there is another act by the name of Punjab Land Revenue Act. Now the land records of Delhi are being mandated to be recorded under these two acts, and there are overlapping areas where these two act functions, which creates anomaly and confusion with respect to the administrative authorities. And secondly, there are multiplicity of institutions which are recording the land records in Delhi. To name some, there are Municipal Corporation of Delhi, the New Delhi Municipal Corporation. Apart from it, there is Land and Developmental Organization within the MOHUA, that is the Ministry of Housing and Urban Affairs. Apart from it, there is Delhi Cantonment Board also, which is maintaining the land records. And this involvement of multiplicity of institutions, it creates a lot of trouble for the urban planners and the policy makers overall to create a sustainable and a viable map for the sustainable development of Delhi in a way. And that is why we decided to come up with this particular bill. And now let us try to look towards the various provisions which have been envisaged in the bill. So the first important provision which have been provided in the bill is the creation of a organization by the name of Delhi Urban Land and Immovable Property Records Authority, and ultimately we will try to learn it through its structure and what are the functions does it tries to serve. So this ultimately authority, it will be headed by Delhi's Lieutenant Governor itself. It will be headed by Lieutenant Governor. However, it will be followed by the members from Delhi's Municipal Corporation, New Delhi Municipal Corporation, and Land and Development Office of Ministry of Housing and Urban Affairs. Apart from it, what are the major functions which have been performed, which has to be performed by this authority? That is, it should create the guidelines, which is a very important thing. That is, what guidelines it will have creating? That is to how to create and manage the data with respect to the urban land which is present with respect to the Delhi, and the immovable properties which are present there in the Delhi, whether be it apartments, shops, or any kind of real estate or commercial building. Secondly, it will appoint officers. It will appoint such class of officers which will go for the survey of both the lands and the immovable properties. And thirdly, it will try to digitize all the data at one place, so that ultimately we are trying to achieve the core objectives which was envisaged in the preamble of this bill. That is to provide access to the people of Delhi so that they can actually see the RORs or the record of rights of their particular land, and they should be able to ascertain the ownership, which will further enthuse sense of transparency with respect to the land management in our country. And apart from it, this particular organization or this particular bill provides for the creation of an urban record of rights, which will contain, as we already noted, that if it is a land, it will contain 4 important aspects, which is ownership, land details, land type, and lastly any financial issues associated with the land, so that if this ROR is present with the public within a click away, it will lead to a great degree of benefits, not only for the urban planners but for the individuals who are involved in purchase of any immovable property or any land within the premise of Delhi. And thirdly, third important provision of this bill is that it includes penal provisions. It introduces penal provisions within its ambit, so that they will be able to charge or accuse any person who has been found to be withholding information about their properties or providing false information. In these 2 cases, it will be a violation of this particular act, which will be punishable under the Bharatiya Nyaya Samhita 2023. And through these penal provisions, the bill actually envisages to remove the opaqueness which exists in our country with respect to the transactions with respect to the land, or whether it be any immovable property with respect to flats, shops, real estate enterprises, etc. Now, what are the significance can we actually expect from it? Now, one of the biggest significance that we can derive from it is the clarity of ownership rights. That is the biggest benefit that we can actually derive from the passage of this particular bill, because since urbanized areas are characterized by the high population density, and urban areas witness a lot of land and immovable property transactions which are usually not captured by the revenue departments or any other department which is catering to that particular need in the urban areas. And what happens is that it creates a lot of ambiguity with respect to who is that particular owner of that particular parcel of land or any immovable property. And with the creation of a centralized digital repository through the provisions of this particular act, we will be able to ascertain the ownership rights. Secondly, since the ownership rights will be clear, ultimately it will lead to a lot easier way to provide for dispute resolution. You will be surprised to know that in our courts of our country, majority of the cases which are pending right now belong to the civil cases with respect to the disputes which relate to the property disputes or with respect to the ownership rights. The third is that it will provide for ease of doing business. How? Because since everything will be transparent, businesses will be able to provide more and more investment with respect to owning such properties. Majority of the time, whether be it any industry or any startup, these companies are very afraid to invest in land because they are not sure about the ownership rights of those particular lands, and they end up not purchasing those lands and shying away from investing in any particular state. So it will lead to more and more investment, which will lead to more and more job creation as well. And apart from it, since it will accelerate the transparency with respect to land management in state of Delhi, it will also create a very facilitative environment for startups like Magic Bricks. Magic Brick is a startup which actually works in the domain of tenancy. It helps people find out the right flats or any immovable property for purchasing or any parcel of land for purchasing. So since it will be very transparent, startup ecosystem can flourish within the state of Delhi. And the fourth important point which we need to note over here is the black money aspect. That is, since it will bring more transparency with respect to the ownership and the transactions which related to the purchase of any land or immovable property, it will lead to reduction of generation of the black money. And these are the major potential benefits that we can actually derive from the passage of this particular bill. So this was all about this particular topic. Now let's come to the next topic, which is Maharashtra Special Public Security Bill 2024. Now this particular topic is a very key legislation which we are learning in this episode of Recitals in Depth. And this particular bill, that is the Maharashtra Special Public Security MSPS in short bill 2024, deals with it is a Maharashtra government's effort to deal with a menace of urban naxalism. Urban naxalism. What do we mean by urban naxalism? That since we usually know that the left-wing extremism or naxalism in short is primarily dominated in the forested regions of our country, where the presence of state or the state agencies are very negligible, and these left-wing extremists, they find it extremely easy to cross the porous borders of the state or to hide from the law enforcement agencies. However, with the effort of the government in the recent years, there has been a constant degree of shrinking in the space which the left-wing extremists had covered in our country. And what it had led to emergence of a new condition. That is, it has been found through various reports of investigating and intelligence agencies that because of the shrinkage of areas of LWE, ultimately these LWE extremists or these antisocial elements are finding their places in the urban areas of our country. And what do we mean by urban naxals? So there is, we can define urban naxals in a way that these are such group of people who sympathize with the cause of the left-wing extremism, and apart from it, they provide intellectual, logistical, and financial support to such Naxal elements. And that is why the Maharashtra government felt that there is an imminent need that they should come up with a new law which should be able to help the governmental agencies of Maharashtra to tackle the menace of increasing urban naxalism in their states. So now let us try to understand this topic in even more depth. So we will again begin with the same thing, that we will first, since we already understood the essence and scope of urban naxalism, we will start with what is the government's approach in dealing with the problem of left-wing extremism. And then we will try to come to the objectives of this bill and the key provisions of this bill, and then we will try to understand how this MSPS is different from UAPA Act, and ultimately we will try to understand why is this law being criticized. So since the Maharashtra government had tabled this particular bill, it received a lot of criticism and pullback from various kind of civil society organizations and activists, human rights activists. So now let us try to understand what has been the government's approach towards left-wing extremism. Now, as we know that this left-wing extremism is extremely infested in areas which are extremely backward areas, which are the hotspot of poverty, unemployment, state atrocities. And because there has been a constant frustration within these segment of people, ultimately what it has led to, that it has created a sense of frustration against the state, which found well within the sympathizers of the left-wing extremism, that they ultimately their agenda is to throw away the yoke of Indian state itself. And where these left-wing extremism is located, it is located in the extremely forested regions, forested border districts and very isolated regions of our country, so that these by the virtue of the geography of such areas, these left-wing extremists are able to hide from the law enforcement agencies. However, because of the very complex nature of the problem which is posed by the left-wing extremism, because it functions in the intersection of various social, political, economic, cultural domain, it becomes very difficult for the government to tackle it. And however, the government has been really phenomenal experience has been shown by the government to tackle the menace of left-wing extremism. To give you a context about it, the government of India in the year of 2015, they launched the National Policy and Action Plan to address left-wing extremism. And understanding the complex nature and the scope of the problem of left-wing extremism, this National Policy and the Action Plan provided for a multi-pronged approach, which comprised of two major elements. One is the developmental elements, and second is the security related initiatives. So the government, while they were actually passing out the National Policy and the Action Plan to address the left-wing extremism, they were very clear in their mind that since the nature of this problem is extremely complex, only security related interventions will never be able to fathom the LWE. So it provided for a multi-pronged approach which provided two ways. That is, both things have to go simultaneously. Both developmental activities and security related interventions by the state and the central agencies has to go in tandem so as to decimate the growing population of the LWE. And you will be very happy to know this, that the government has been very successful with respect to the decimating of the LWE factions in our country. Now, what are the various developmental activities that the government is providing in such areas? So, the government of India is already providing a lot of flagship schemes which are readily available for all the states. However, for these states which are infested with LWE, government is also providing additional support through various financial instruments to provide for more infrastructure, to provide for more road connectivity, telecom connectivity and skill development. To do this, government is providing, there are certain schemes like special central assistance, secondly, security related infrastructure, security related expenditure scheme, etc. Apart from that, on the security related front, the government is providing a lot of support to the state government. Now, since we know that the police and the public order falls under the state list of the 7th schedule. So ultimately it is the state government's responsibility to tackle the menace of LWE. However, given the nature and the scope and the larger scope of the LWE, state governments do not have those kind of resources to tackle it on their own. And in that front, the central government is actually providing them a lot of support with respect to the modernization of police forces. Modernization of police forces. Secondly, providing battalions of various central armed police forces. Battalions of CAPF, that is Central Armed Police Forces. Apart from it, sharing intelligence, vital intelligence with respect to the movement of various kind of Naxal activities. And apart from it, creation of various kind of infrastructure with respect to the fortification of police stations. And providing the state governments with modern arms and ammunition so that they will be able to tackle the onslaught of the left-wing extremists. Now, these are the major approach which has been followed by the central government of our India. But what kind of improvement did it make with respect to India's progress with respect to controlling that LWE? And India has made phenomenal progress. To give you a context, in the year of 2013, we had almost 128 districts in our country which were considered to be as LWE infested. However, after the span of only 9 years of launching the national policy and action plan to address the LWE, there had been a significant reduction in the districts which are infested with LWE, and there are only 38 districts in our country right now in 2024 which can be categorized as the red districts or which comprise of the red corridor. And these districts are identified by the Ministry of Home Affairs. One important facet which you should need to know from the prelims point of view, that Chhattisgarh forms the largest state to have the largest number of districts, that is 15, which is followed by Odisha, which comprises of 7 districts, and then Jharkhand, which comprises of 5 districts. And ultimately, these are the top 3 states having the largest number of districts which can be considered as red districts or comprises of red corridor. And ultimately, this was the entire snapshot with respect to how Indian government is trying to decimate the problem of left-wing extremism. Now we will come to the key provisions of this particular bill, and then we will try to understand why this particular bill is being criticized and what are its inherent distinctions with respect to the other important act which is used to control the LWE, which is the Unlawful Activities Prevention Act or UAPA. So the first important element which we need to note over here is the definition which it provides for unlawful activities. So this bill provides for the definition of unlawful activities, and what does it comprise of? It comprises of a danger or menace to public order, peace and tranquility. While you are reading this thing, keep in mind the broad nature of definition which this bill has provided to the unlawful activities, because it will give unnecessary and undue power to the law enforcement agencies that they can accuse anyone of doing unlawful activity and they can hold them in jail without any warrant. And this is what we are going to discuss when we will be discussing the criticism with respect to this particular bill. Apart from it, it also provides that any interference with the maintenance of public order or administration of this particular law will also comprise of unlawful activity. Apart from it, it involves that indulging in or propagating the ideology of violence or armed rebellion. It also constitutes to be a unlawful activity. And second, lastly, if anyone encourages or preaches any disobedience to established law, this again is a very, very vague definition. And apart from it, it provides the state agencies to declare any organization to be unlawful. So the bill empowers the state government to declare any organization as unlawful which propagates the ideology of armed rebellion against the constitutionally mandated regime. That is the keyword over here, that if any organization is espousing or promoting armed rebellion or the ideology of armed rebellion against the constitutional mandate, the state government will be empowered to categorize such organizations to be unlawful. And after that, there is a legal review mechanism which has been propounded by this particular act, which goes like, as soon as the state government will categorize any organization to be unlawful, it has to provide that like memorandum within 6 weeks to an advisory board. Okay, so as soon as it will be declared, any organization will be declared an unlawful, it has to send this particular memorandum within 6 weeks to an advisory board, which will comprise of 3 qualified individuals, which can be a current judges or former judges or any person who is qualified to become a high court judge. And then the board, that particular advisory board, will have to submit a report within 3 months after going through and scrutinizing various kind of evidences which the state government has put or has quoted to make that particular organization to be unlawful. And then after due scrutiny, if the board finds or the advisory board finds that the government is not correct in categorizing a particular organization to be unlawful, then in that case the government has to bring back their notification or to recategorize that organization as to be a normal organization. Apart from it, this particular act also prescribes for the offences and punishment. So since this bill is very harsh on tackling the urban Naxalism, it provides for various kind of like offences and punishments, and it categorizes if a person is accused, then all the offences will be cognizable and non-bailable with respect to this particular bill. However, from the examination point of view, this imprisonment and fine is not that relevant and important. Okay, and the last important provision of this bill is the seizure and the forfeiture powers which it provides to the state enforcement agencies. So what it tells is that as soon as the state government will define an organization to be unlawful, it will be as a competent power of district magistrates or the police commissioners of that particular district where that organization is located to forfeit or seize both immovable and movable properties of that particular organization, which is again a very important and a very powerful step to curb the menace of urban Naxalism. After that, we will try to understand how this MSPS is different from UAPA, that is the Unlawful Activities Prevention Act. So, as we know that the UAPA is a very broader act. It is a central act which can cover various aspects of terrorism. It can also go for LWE, it can also go for insurgency, it can also go for terrorist activities. However, the scope of MSPS is quite limited, and it is limited to only urban Naxalism and related activities in Maharashtra itself. Secondly, under UAPA there is a tribunal which is led by High Court judge, which verifies the state's accusation with respect to any kind of activities which is considered to be unlawful. However, we just recently noted that in the MSPL bill, it provides for the creation of an advisory board which comprises of 3 individuals, which can be a current High Court judge, a former High Court judge, and any person who is qualified to become a High Court judge. And lastly, the state enforces, any state in which the UAPA is being invoked. For instance, in this case Maharashtra, it enforces the Maharashtra Control of Organized Crime Act 1999 along with the UAPA. However, in the case of invocation of MSPS, no such case is required, that the state do not has to actually invoke both MACOCA and UAPA so as to hold the urban Naxal to be accountable. However, the last thing that we need to note in this particular topic is why is this bill is being criticized. So let us try to come to the critical aspects of this bill. Now, one of the most fundamental aspects which we need to note over here is that why do we need a separate legislation to curb the menace of urban Naxalism? Okay, it is agreed that urban Naxalism is emerging in its different form in various cities of Maharashtra. However, we have enough legislations in our pocket with respect to Bharatiya Nyaya Sanhita or UAPA or Maharashtra Control of Organized Crime. So why there is a need to bring in again one more legislation which will create an unnecessary complexity in the legal ecosystem? So that is the first point. Secondly, as we already noted, that the act or the bill provides for a very vague definition of unlawful activities which can actually facilitate malicious use or invocation of this act, so that it is based on the whims and fancies of the police authorities that they can take in charge any particular person for violating or performance of unlawful activities, since the definition is so vague, and it will be left to the court of that particular state to define what is actually being considered as unlawful. Thirdly, since we already noted, since the definition is so vague, it can be used by the police in a very malignant and malicious manner, and it can lead to the erosion of rights and liberty of the individuals. Apart from it, the advisory board, as we noted, it leaves a space for the discretion with respect to the government, that the government can involve their own favorable candidates who will constitute the advisory board, and it is not good for the checks and balances and the accountability of the government. And lastly, prosecuting non-members. The bill also envisages or provides for the prosecution of non-members of that unlawful organization which has been declared by the government, and it actually impinges on the liberty of the individual. So ultimately, these are the major criticism which has been held against this particular act. And what we need to understand is that Naxalism is being shrinking with a lot of pace with respect to the government and the kind of activities which the government has done. And by continuing the security related measures and the developmental related measures in tandem simultaneously, ultimately it will lead to the decimation, complete decimation of LWE. So this was all about this particular topic. Now let's come to the next topic, which is the illegal coal mining issue. Now what is this particular issue? So recently there was a discussion, or there was an issue where almost 5 persons died in Gujarat. 5 persons died in Gujarat by asphyxiation. What is asphyxiation? It is death by choking or death by not having enough oxygen to breathe. And why it happens? Because the coal mining or the coal seams are filled with very poisonous gases like carbon monoxide, methane and hydrogen sulfide. And the oxygen, the concentration of oxygen while going for the illegal mines are very less. And ultimately it led to the death of 5 persons, which is very unfortunate. And this is why we are trying to learn about the nitty-gritties of the illegal coal mining which continues to happen in our country. Now before we go on and proceed with the why of illegal coal mining, we should basically take a brief snapshot with respect to the coal production in our country. So with respect to the coal reserves, India is the 4th largest country with respect to the coal reserves. 4th largest country. And with respect to the production and consumption, India is the 2nd largest country in the world after China. Now, one very logical question should come to your mind, and it should strike you that since India is having the 4th largest reserves in the world, India is the 2nd largest country in the world to produce and to consume it. What is the need to go for illegal mining leases or illegal coal mines? And this is what we are going to discuss right now. So why illegal coal mining? So ultimately what we need to understand is that a very important thing or an interrelation which we can make with the Naxalism and coal mining also. Now since we noted that India is the 4th largest reserves within the world for the coal, now you will be surprised to know that Jharkhand plus Odisha plus Chhattisgarh comprises of 70% of the coal production. And one more very important critical thing that we have to note over here is that these are the same 3 states which had the maximum numbers of red districts or the districts which are infested with left-wing extremism. So there is a very strong correlation. Or is there any correlation with respect to the mining areas and the people's frustration with their displacement which is happening because of a lot of mining activities, and the people are left with no land, and the people are forced to vacate their traditional ancestral lands, which creates a lots and lots of discontent, frustration and irritation among the citizens of these particular areas, which is basically leveraged by the left-wing extremists, and they take these people within their fold. And this is why the problem of left-wing extremism is extremely complex. So that is how you should try to learn to interrelate or correlate the learnings which we go for different topics as well. So ultimately these three states provide for 70% of the coal production in our country. However, we also need to note that the ultimate coal abundance and poverty and the incidences of poverty and unemployment are congruent. There is a coal abundance in these three states. Apart from it, these three states are one of the most poorer and backwardly states in our country. And it provides for such kind of temptation that people go for illegal mining in these areas so that they can make quick money with respect to mining of coal. Since the people in these areas, they feel that since mines are there which have been closed or abandoned, it will be good for us that if we can mine it with the help of unscientific methods, and we will be able to make money. And that is the core issue, that illegal mines continue to operate in such areas. Apart from it, there are weak mining regulations and support from political leaders. So there has been a lot of laws which are not being implemented. So if there is a law and if it is not being implemented, ultimately there will be no presence of any administrative state on the ground, which will lead to proliferation of more and more illegal mining activities in our country. The third is complex land ownership patterns. Now, as we already discussed, now since the land ownership patterns in forested areas and in the areas where the mining activities are taking place are under constant dispute, and which leads to certain nefarious elements to start illegal mining in those lands. Now, since the land ownership issues are pending in various courts, so the land cannot be utilized in those cases. However, utilizing the pendency in the court, certain nefarious elements, they use that particular land to go for illegal mining. And lastly, there are inadequate penalties. So there is no deterrence by the laws which are usually prevalent in our country, so that it should be able to deter the antisocial elements from involving or indulging in the illegal mining activities. So these are the major reasons that why illegal mining activities are taking place in our country. Now let us try to come to the facet with respect to why workers are dying in the coal mines. Now, one very important thing which we need to note is that ultimately these are the illegal coal mines. So there are no labor laws or the safety conditions or the safety norms and rules and regulations are being implemented over here. And this forms the major core nucleus reason with respect to the increasing number of deaths with respect to the illegal mines. So the first point, as we already discussed, that is the lack of safety equipment and violation of safety regulation. So since it is extremely illegal in mining, there are no legally provided leases. So ultimately it leads to a lack of safety environment, and people fall prey to poisonous gases within those illegal mines, that they end up dying suffocating on various poisonous gases like sulfur dioxide or methane or hydrogen sulfide, etc. Second is lack of proper structural support with incidents of natural hazards. Now, since these mines are again illegal, such mines do not have core structural supports which actually supports the wall of the underground mines. So in such kind of mines, it is very common that some kind of landslides, internal landslides happen, which leads to the burying of individuals, which leads to their unfortunate demise. And apart from it, there is a lack of training and awareness, because ultimately these people are informal laborers. They do not have the expertise or the skill set which is deployed to actually mine the coal and to understand whether a particular mine is feasible and safe enough to take out coal from that particular area. However, these people are absolutely informal, untrained, uneducated, and their temptation and their frustration to get more money brings them into this illegal mining ecosystem. And lastly, overworking and fatigue with exposure to toxic gases. Now, as these laborers are very informal, they are being paid by third-party contractors on a daily basis. So these are daily wagers who are not having proper safety equipments like gloves, masks, eye glasses, etc. And ultimately, it provides them exposure to a lot of toxic gases, which leads to their death as well. So ultimately, we need to understand that what the government is doing to, or what kind of initiatives the government is doing or taking to curb the activities of illegal mining in our country. So there are various legal, administrative and e-governance initiatives the government is doing to actually curb the menace of illegal mining in our country. Let's start with the first point, which is the Coal Mines Special Provisions Act. With the help of this act, what government did is that it digitized the coal auction process. And since the coal auction process got digitized, there was enhanced transparency, and it led to more and more participation of the private players. And more private players were able to get the lease, which provided them the authority to mine coal. And ultimately, with the presence of more formal players, more authorized players in the sector of coal mining, it led to the depletion of illegal coal mining. Secondly, we need to note is the Mines and Mineral Development and Regulation Amendment Act. What it did is that it introduced very stringent penal provisions so that they should be able to create more deterrence in the society. And apart from that, it gave the state governments more powers to keep the coal mafias under check. This is the core important aspect which has been provided by Mines and Mineral Amendment Act. Apart from it, Government of India also provided for the starting of such mines which were abandoned, so that by the virtue of that, what had happened is that since the mines were abandoned, illegal activities were easy to take place in such mines. However, with the beginning of such mines, with more proper structural elements and safety features, government is able to lease such mines so that more and more formal private players are coming over there, and ultimately it will lead to defacilitation of illegal players over there. Apart from it, more and more adoption of new technologies like drones and geospatial technologies to constantly monitor the mining areas and the mines, so that we will be able to understand, the administrative authorities and the state government authorities will be able to identify whether the mining activity which is being taking place in a particular mine, it is actually legal or illegal. And drones and geospatial technologies are providing a great degree of help to the administrative authorities. And lastly, there is a app by the name of Khanan Prahari app, which is an e-governance initiative by the Government of India, which provides for that every individual citizen, if they come to know that there is an illegal mining activity going on in a particular mine, they can come to this Khanan Prahari app and they can get their complaint registered in that particular app, which will be then relegated or sent to the higher authorities in the coal ministry. And through this set of or a matrix of governmental initiatives, government is trying to decimate the problem of illegal coal mining in our country. So this was all for this particular topic. Now let's come to the last topic of today's discussion, which is the genetically modified crop. And what is the core issue right now that today we are going to learn? That is, the Supreme Court delivers a split verdict on the nod for GM mustard. So recently Supreme Court has provided a split verdict. It was a 2-judge bench which provided a split verdict. So both the judges were not able to get to a convergent point with respect to it. So now let us try to learn this particular topic. So again, we'll start with the same thing, that we'll start with what are GM crops. Then we'll go for to understand how they are regulated, what is that particular organization which is regulating the GM crops or the usage of GM crops in our country. And thirdly, we'll try to learn about the genetic engineering appraisal committee, and lastly then we'll try to understand what were the observations of the Supreme Court in this particular matter. So what are GM crops? So GM crops, as the name suggests, which is the genetically modified crops. So GM crops are those crops which are actually modified with the help of certain genetically engineering tools like CRISPR to provide certain desirable traits. For example, such kind of modifications can be brought in any particular crop by like changing their DNA structure, so that certain more favorable traits are being shown by that particular crop, like they are more pest resistant, they are more drought resistant, they will need less water, they will produce more and more yields, and these are the basic definition of a GM crop. And GM crops are also known as genetically engineered plants or transgenic crops or LMOs, that is living modified organisms. How did it evolve? So they were first introduced in the United States of America in mid 1990s, but right now it has been practiced globally. And in India, we started with the introduction of BT cotton, which is the only GM crop approved for cultivation. So when we started in 2002, only few selected areas were trying to grow the BT cotton. However, the kind of like buffer or the kind of safety it showed to the pink worm balls, so there is a very important pest which actually threatens the cotton, that is a pink worm. So it provided a great degree of refuge. So right now 90% of the cotton area in our country is being actually cultivated by the BT cotton itself. And there are several more crops also like chickpea, pigeon pea, corn, sugarcane, etc., which are in various stages of return and free trials. Although the BT brinjal, similarly this brinjal was approved by GEAC, that is the Genetic Engineering Appraisal Committee, in 2009. However, due to various kind of oppositions by civil society organizations and political parties, it could not see the commercial usage of it. So now let us try to understand what do we understand by the GEAC, that is the Genetic Engineering Appraisal Committee. Now mind it, GEAC, which is short for Genetic Engineering Appraisal Committee, is the apex regulatory body which governs the usage, import, export, storage of GMOs, that is genetically modified organisms. So as we already noted that it is the apex regulatory committee which was formed in the year of 2010. And one very important facet which we need to remember from both mains and pre point of view, that it was created under the rule of manufacture, use, import, export and storage of hazardous microorganisms and genetically engineered organisms cells, rules of 1989, which rules were formed under the Environment Protection Act of 1986. And this committee is chaired by a special secretary or an additional secretary of the Ministry of Environment and Forest, Ministry of Environment, Forest and Climate Change, and co-chaired by an expert nominated by Department of Biotechnology. And it comprises of 24 members from the Ministry of Industrial Development, Department of Biotechnology and Department of Atomic Energy. And they meet every month to review the applications in areas with respect to the usage, import, export of GMOs or the genetically modified organisms. And what are the major functions which are being performed by GEAC? So it reviews, monitors and approves all activities involving large scale use of hazardous microorganisms and recombinant research and industrial production of or import and export of such genetically modified organisms. And apart from it, it also does the same thing with respect to the proposals, that if any research and developmental organization, whether be it in the state government, central government or in the private sector, if they come up with certain proposal with respect to the cultivation of any kind of GM crop, ultimately GEAC is the final approving authority. And it scrutinizes the various kind of evidences which are being provided by the various research organizations, and then it provides for the approval with respect to the usage of that particular GM crop. And now let us try to come to the core argument of the Supreme Court, that why ultimately it did end up giving a split verdict. So there were, as we already noted, that it was a 2-judge bench, and there was one Justice Nagaratna and Justice Carroll. So what was the observation of Justice Nagaratna was that she ruled against the release of GM crop because she felt that the GEAC did not bring into existence the local studies which were done on the impact of usage of GM crops on the larger ecosystem. So there can be a large creation of toxicity within the cross-pollination with respect to the original or non-GM crop of that particular species, and it can also create some kind of toxicity within the animals for which these GM crops are being given as fodder material. Apart from it, Justice Nagaratna also noted that this particular approval by the GEAC, it was in gross violation of the principle of intergenerational equity, and it did not forward the public interest. And she suggested that the precautionary principle has to be kept in mind while providing such kind of approvals by the GEAC. However, on the other hand, Justice Carroll had some other views. He did not find any kind of problems or arbitrariness with respect to the procedure which was followed by GEAC, and he was fine with respect to the approval which was provided by the GEAC. And what he had noted is that the environmental release following the tests and trials were in line with the development of a scientific temper and abided by the precautionary principles. So both the judges could not come into the final convergent point with respect to the decision of this thing. So both the judges decided to send this particular judgment to the Chief Justice of our country, so that, and suggested the CJI of our country to create a larger bench to decide the final decision on this particular matter. Now, as we know that the climate change is one of the biggest concerns the global community is facing, and GM crops hold a great potential with respect to the increase of yields that they can provide and the pest toleration and the drought toleration they can provide. However, providing for the opportunities on one hand, we cannot actually ignore the precautionary principle that the fruits of the scientific development, it should be released only when we are absolutely sure with respect to what kind of threats which are associated with it. So this was all for this month's recital in depth. I hope you will find it very informative and enriching experience. Stay tuned. See you next month.